So if it's one that directly relates, then the board should consider and should deny. If it's a Medicaid fraud issue related to a dental practice or whatever it may be, then the board should consider that charge.
What about a situation under the category of everybody comes from somewhere? It's very difficult to get an insurance license if you have any sort of theft-related criminal past, no matter when it was. I mean, there's a credible conversation about, you were working part-time and you're 19, 20 years old and it's 20 years later or whatever the scenario may be. We've heard those before. But that's a theft-related crime, or if there's some sort of misrepresentation, some sort of fraud, some sort of not in the statutory context that Mr. Reeves and I and Ms. Travis were struggling with several weeks ago on another bill, but it doesn't relate to insurance. It could have been in some past life not having to do, let's say, with insurance. But it's still that type of crime not related to a particular occupation or profession.
The board could still rightfully consider that offense. They just need to do so within the framework that's provided on lines 770 through 779. And I think with respect to what you're referring to, as far as the nature and seriousness of such felony or crime involving moral turpitude and the relationship to the occupation, but also with all circumstances that are involving the felony. So the intent here is to allow the board to consider all of these things, but to do so within some workable framework. In no way does this bill tie the hands of a licensing board to require adoption in that instance.
Can't they do that now?
So interestingly enough, when we included Q, there was a relation to A where, so again, looking in the framework of this broader code section, A granted the board to consider a felony or crime involving moral turpitude. Q, when we looked at it, said only felony. So the implication there was, do you not consider a crime involving moral turpitude within the framework? That was not the intent, but that's the drafting and statutory interpretation implication. But also we added in A some things that were not listed, made it clear that if you pled a NOLO on a charge, that the board can still consider it. Before it was silent as to that, but allowed the board to consider felonies and crimes involving moral turpitude.
So is the intent to go ahead and clarify that whereas it may appear that under certain circumstances the board or commissioner, depending on the situation, shall not consider certain things, this opens up the ability to consider in case there was any confusion on the past drafting of the statute?
That's correct. We're saying board should consider all of it, should bring it all in, but consider it within the framework, if that makes sense.
Thank you.
Moving on to page 23, I think that gets us to part 3, section 3-1. And then pages 23 through down to part 4 on page 27, we are allowing the Department of Community Health to actually go through the Medicaid determination process for inmates for the purpose of medical treatment and also for the purpose of placing parole-eligible inmates in long-term care facilities. And the good example that's given to me here is you have someone that needs medical care, and the way that it's currently set up, we're not able to draw down federal dollars otherwise would get. We can actually draw down federal dollars to actually pay for those costs by allowing DCH to go through this Medicaid process. And then,
So is this, is the intent here is to pipeline these individuals directly into Medicaid?
So
That's what I see.
they would be paroled into
I see.
Right. So these are folks who would be eligible for parole, but otherwise they don't have a place to live. So if under a new federal interpretation of the current law, they can be paroled into a restricted facility and pull down federal Medicaid dollars for that. But also when you have an inmate in the jail who takes a visit to Grady, that it pulls down federal Medicaid dollars for that also. Right now, the state's paying for those medical expenses. This is an attempt at what would be a significant cost savings and what some other states have taken the route to try and explore after the change in federal determination. Because under federal law, you're ineligible for Medicaid while you're incarcerated.
Ms. Silcox.
Yeah, I believe this goes to part of the waiver that Grady has discussed, the 1115 waiver, that it would take into account some of these types of situations for the expansion of the Medicaid program under receiving these federal dollars.
So I can't speak to the waiver. I think this is a different but parallel issue that relates to the CMS determination as to what constitutes the incarceration.
Okay.
Basically, you had a pilot program in Connecticut and a few other states where they were paroling Medicaid-eligible individuals into a restricted, almost nursing home hybrid facility, but one with a heightened security, and we're able to pay with, or to pull down federal Medicaid dollars to pay for part of those expenses. I can't speak to the waiver, but
Okay.
the state has begun the route of suspending rather than terminating Medicaid while you're incarcerated in jail. What we have come to find out is that some inmates who are in, and it's not just Grady, but in a county facility and are moving to get medical treatment, under our current framework, we were ineligible to use federal Medicaid dollars for them.
Thank you. I know that Grady is moving people out because the demand for their beds is so huge
Right.
that they are relocating people regularly to longer-term care facilities.
Mr. Trammell.
Thank you, Mr. Chairman.
Shoot. I'm going to go ahead and press the button there. Oh,
Let's try again.
now try it. Go ahead and try it. Hold up. Okay. Take your,
Is it worth it, Bob?
okay, it should be on now. No, you got to stop pressing the button. Okay.
Does that work? All right. It's my fault. So not to get too in the weeds, but I just want to understand, is this where if they're presently eligible for Medicaid, this would allow a path for people who are incarcerated to be released earlier? But do they have to be presently eligible, or are you saying that there is a change in federal law now that creates a category that we previously have not had the opportunity to obtain coverage for these folks?
So I think it's a bit of yes and no to both. These are the parole individuals that wouldn't have a place to go otherwise and are paroled to a specific facility. Prior interpretation has said that still counts as incarceration and thus ineligible for Medicaid. So if you're otherwise eligible, now we have this new avenue open. With respect to some of the other details, I know Joe Hood, Deputy Commissioner at DCH, is here and can probably speak to more detail on it. But I think the intent here is to say that these are individuals who would otherwise be eligible, but for incarceration.
Okay, so the question and concern, and this is some states, and not to devolve into a discussion about expansion, but this is an area where some states have recognized savings because with expansion you expand the number of people who are otherwise eligible for Medicaid. And the question that I would have is, what is the universe of our prison population who would otherwise be eligible? Because if you're 18 to 65 and you don't fall in one of those medically needy classifications, and you're single, you're not eligible for Medicaid. So that's what I'm interested in is, the universe of people who would be eligible. I think it's a great idea. I just think that the application may be limited because of our Medicaid restrictions.
Do you want to have Mr. Hood respond?
Yeah, that's fine. And then I think we have some follow-ups. They're all fleeing.
So
They're all a bunch of flight risks.
So my name is Joe Hood. I'm Deputy Commissioner at the Department of Community Health. So specifically to your question, when we brought this to the Criminal Justice Reform Council, we had the Applied Research Services firm do an analysis of the Department of Corrections, and we looked at over 60, and we had over 1,700 individuals who were over 60 that are looking towards aging out where they would be eligible for Medicaid. My understanding is basically what would make them eligible is the age, they're indigent, which almost all of them are given their prison sentence, and then they would have the loss of 2 or more services. So they'd have to undergo 2 or more physical services for assistance. So they'd have to go and get, a referral and go through the normal process just like anyone else. When he looked at that, when the ARS folks looked at that, they think, it might be as many as 200 that are going to be Medicaid eligible under our current guidance. We're not talking about expansion, just under the current rules, except for incarceration, as Kerry referenced, they would most likely be eligible for Medicaid. So what happens today is there is a provision in state law that says we cannot use Medicaid eligibility while they're incarcerated, and we can't make a Medicaid determination while they're incarcerated. So it's not that they're eligible. We don't know if they're eligible or not for Medicaid, and the law specifically prohibits us from using that in state statute, not on the federal level. So what we're asking to do is to strike that language so we can make Medicaid eligibility determinations. And so a nursing home that would be secure, we've authorized one in the state of Georgia that can do this in Milledgeville, so that they could look at that and say, yes, we would accept that person with Medicaid as a funder. That gives the parole board the ability to consider them, knowing that they'll have a secure residence that they can set as a parole condition, whereas today we don't have that ability. We can't declare them eligible and find a funding source, and there's no way for parole to make the determination.
Mr. Chairman, if I might just make sure I understood what you're saying. So you're saying that the target group for this is about 200 in number, aged over 60?
That's his educated guess at the population. That's standing population today, though. That facility that I'm referencing has a capacity of like 280. So to give you a cost savings, we were looking at somewhere around their cost. If we were to keep them incarcerated, minimum somewhere around double what it costs to incarcerate a normal individual. And as that population grows, we don't have facilities, from my understanding from the Department of Corrections, to do that. So we'd have to actually have an out cost to build a facility that would be appropriate. So you're looking, just on 100, you're looking somewhere around $5 million on a single year cost on differential if they are paroled into that facility. So I mean, it's huge savings in the out years.
And Mr. Chairman, one final question: is that the FMAP? Is that the 68 cents?
Yes, sir.
Thank you.
Mr. Bodie, did you have a question for this witness?
Actually, I do, but it's not kind of tailored towards this. But I'm glad that I have you in the room, and I have my friends from DDS as well, because it gives me an opportunity to talk about some our local delegation in Douglas County have brought up, not a part of this bill, but I want to know if you all can consider. One of our judges out in Douglas County, Judge William Bo McClain, wanted to always bring to our attention issues with mental health and individuals who have mental health needs not be able to get out of jail because they do not have the proper identification to do that. So is it any types of talks with criminal justice reform on getting maybe a white card or a mental health ID card so these individuals can get Medicaid and get out of their jails and be able to, get them moving a little bit? Because photo documentation and official photo state documentation is a big problem across the state.
So I don't know about in local jail localities. I know in prison that's part of our reentry initiative, where we work with DDS to try and get them either, if they qualify for a driver's license or a state ID. You can get a regular state ID through that process. I'm not aware on the local level of that.
So it's nothing uniform across the state that mandates or have a process for doing that?
Not that I'm aware of.
Ms. Dickerson?
Thank you, Mr. Chairman. When you talk about these Medicaid recipients that are coming out, and you gave the age between 60 and 65, what about those younger, those that are younger than that, that would still need medical attention, especially in the mental health arena? Because I've seen some of that and I've heard about those problems as well. Would they be able to, have the same services available to them?
So the change is in all three sections. It's in all three qualifiers. So mental health would be one factor. If they would qualify for Medicaid and there is a facility that parole could consider for them, then that would apply to them equally. We're striking the language, or propose to strike the language, for eligibility in disability and in aged and blind. So the
Okay.
three qualifying factors, so it could be in any of those.
Okay, thank you.
Thank you. I don't see any further questions for this witness. Just for Mr. Miller and Senator Strickland, with regard to the pipeline, the Medicaid pipeline for these individuals, who else, what precedent do we have in other areas where we're pipelining individuals into Medicaid?
I can't say we would necessarily have a precedent. That might be another question for Joe if we had a precedent. I think the point here that we're trying to get at is cost savings for where the state would otherwise be picking up the entire tab for medical expenses, and allowing them to go to a facility where, under this change in interpretation of federal law, we can draw down those federal dollars.
Senator, do you want to continue on, or?
Sure. So we now can move into Part 4, and this is the last section of the bill. What we're doing here is enhancing, if you will, the penalty for certain offenses that involve firearms, in particular the second or subsequent offenses of some of these, and they're all listed out here. The first one being under Section 4-2, criminal use of an article with an altered ID mark, and for where it involves a firearm for the second or subsequent offense, we go from 1 to 10 as it currently is to 5 to 10 years on the sentence on that. And then Section 4-3 deals with the offense of transferring a firearm to an individual other than the actual buyer. And again, as we see, starting on line 959, for the second or subsequent offense, we go to 5 to 10 instead of 1 to 5. Section 4-4 deals with possession of firearms by a convicted felon and first offender probationers. Same thing, from 1 to 5 to 1 to 10. And then we see in Section B, point 1, and this deals with someone that's been convicted of a forcible felony. We go, in that situation, the second offense goes to 5 to 10. Mr. Chairman, that's the bill.
As I've gone through, and maybe other members have too, I've been trying to, of course, you're looking at particular sections and then listening to the author and listening to the questions and going back and forth and having a multiple part conversation in your own head on as to what you're hearing, what you're seeing. I'm trying to draw the distinction in the bill, and maybe other members are too, in terms of the real mandates that are in the bill as opposed to what are ultimately suggestions, what are ultimately aspirational goals, for the courts, understanding that, the court will consider certain things and perhaps put them higher on the priority list in one circuit versus another. And so I'm trying to figure out where the real, other than the last part, on the weapons, on the firearms, upward departure on sentences. But other than that, I'm trying to see where the real mandates are.
Well, I would point to the council's general philosophy has always been to retain judicial discretion. And we've done this in a number of different areas in years past, and this committee has carefully considered the recommendations of the council in those areas where we said we didn't want to tie the hands of judges, but to point them to things that need to be considered in the context of certain scenarios. And I think it's an appropriate recognition of judicial discretion, but also broader policy goals, whether it be with respect to misdemeanor bail or other sentencing practices done in years past and considered in years past by the council.
Any further questions for the author, Mr. Miller? Mr. Setzler?
Hey, Mr. Chairman, although it's a little outside this bill, I want to get your opinion. I know much of what you're doing in here, or there's parts of this obviously that address record restriction for first offenders. Is the absence of record restriction for certain felony offenses in this intentional? I know there's some bills that have been proposed that would address that. Could you speak to that issue that's before our this committee of record restriction for felony offenses? Not included in here for a reason? Is it something that's, I mean, could you just address that more broadly for me?
I could address it in the context of what the council considered and discussed, and the council really kind of came down to, which you can read in the council's report as well, to the idea that concept should be considered. Outside of that, I would just mainly point you to the report for the Reform Council.
Forgive me for just asking for that summary. I've not studied it on that particular issue as such. Is there if in this process those ideas were introduced, I'm not suggesting to offer an amendment to this bill for that, but as we think about the careful balance we're seeking to strike here, I know there's a push among some in the Capitol to address this year, address the issue of record restriction for convictions, not first offender treatment or otherwise. Could you speak for the governor's office on that question?
I really cannot, with respect to my other day job, that outside of the work of the council. But what I will say is that the council thoroughly considered the concept of record restrictions outside of first offender. And I think some of the information that the council received with respect to what other states are doing is enlightening in terms of where Georgia is relative to those other positions. Now, we work long and hard to try and get everybody on the same page, and even a bill like this has already drawn considerable criticism and support on different sides. But nonetheless is the effort of the council to try and get various stakeholders on the same page. And I think we've succeeded in that with our support from prosecuting attorneys, support from judges, and support from other stakeholder groups.
So it's fair to say that this is an effort to try to kind of get to 91 votes and 29 votes and get to a yes that can move, and anything beyond that, maybe there might be some interest, but it wasn't important enough to, that's not the right word. You were just concerned about the balance. This is something you think we can get the consensus on, and felony conviction restrictions maybe more of a reach that you were concerned about?
This is what the council recommended. It was the balance they were able to agree on, and we were able to pass unanimously out of the Senate. Anything outside of that would be outside of the agreement that was made by the council recommendation. We took that recommendation and made it into the bill, and so anything else would be a broader discussion that could be had.
Any further questions for members of the committee? Seeing none. Thank you very much, gentlemen.
Thank you. Appreciate y'all.
Thank you. Mr. Weaver, are you still here?
Chairman Golick, members of the House Judiciary Non Civil Committee, thank you again, and thank you, Chairman, for allowing me to speak on this important matter and pending before you in regards to Senate Bill 407. I do have a few concerns as a citizen, and I do think that it would be noteworthy of the full committee's consideration, so I'm going to bring them to your attention now during the public hearing portion of this matter. Before I begin in placing my comments, I would like to meet out that I had, in fact, had the opportunity to meet with the author, Senator Strickland, in his office, and this is something that he is familiar with, so it's not anything that hasn't been addressed with key stakeholders prior to me presenting it to you in verbal comment. As many of you know, I've been a strong advocate for our Second Amendment rights over the years here at the state capitol, and as a private citizen, I'm vested heavily on several different matters that's been pending before the General Assembly, and I want to make sure that all my comments that I place in regards to my remarks are and consistent with section, part 4 of the bill in regards to the firearm-related matters. So I'll keep my comments constrained only to that part, and I won't venture to make any comment on any other portion of the bill. And then I'll address them on a section-by-section basis, starting with section 4-2 on line 934 through 942. This is the part of the bill that regards the criminal use of a article with an amended mark or something that's concealed, falsified, fictitious, that's an intent to evade capture or to elude law enforcement. And to the extent that the Georgia General Assembly and the governor's floor leaders want to criminalize more seriously those offenders or bad actors who would misuse firearms, I'm on board with that. However, the bill as proposed in specificity on line 935 seeks to make it a felony to use an article other than a firearm that would, I guess you could say, to remove the serial number or to scratch off the serial number. And when you look at the definitions of what some of these items are under lines 924 through 929, you get words like dictaphone, vacuum cleaner, sewing machine, washing machine. To me, it doesn't seem to be fair to put those in the same category as a firearm. So it is on that basis, if it should be permissible, I would ask as a citizen that the committee explore the as to whether or not the author would be amenable, or as to whether or not, from a public policy standpoint, it would be appropriate to change the language on lines 935 to remove the felony criminal offense for certain non-firearm objects. It just seems to me that bringing the hammer down for a stolen sewing machine that's had the mark removed to the same extent that you would want to bring the hammer down for a firearm, it just seems to me to be a little incongruent. So I would ask that the committee explore as a matter of public policy as to whether or not that should be a misdemeanor as opposed to a felony that's been ventured there. Under section 4-3, in regards to knowingly providing a firearm to a prohibited person, I certainly can better appreciate the General Assembly's willingness as a matter of public policy to prohibit that conduct. Certainly, you wouldn't want to have bad actors knowingly providing firearms to other bad actors. However, this is this particular code section 1611-113 was something that one of your colleagues, Representative Petrie, had explored from the Chatham-Savannah area. He actually had a bill upstairs in the House Public Safety and Homeland Security Committee that actually touched on this very code section. And that measure actually passed the full House and is actually over in the Senate Judiciary Committee. I have the current copy here that's on file with Chairman Stone and the other Cameral. And this, in order to get through the House Public Safety and Homeland Security Committee, they actually put an affirmative defense on here that's not included in this bill. And I'd like to see the affirmative defense that was approved by the full House and that was approved by your colleagues in that committee to be wrote into the bill here, because I'm fearful that if it's not put in the bill here, I'm fearful that if the governor were to sign this bill first, if it were to get to his desk, and then this bill, the affirmative defense that your colleagues wrote into it would be wrote out by the Georgia Code Revision Commission, and it would not become part of Georgia law under code revision. Okay. Yeah. Thank you, Mr. Chairman. I'm just fearful that without making a conforming match under this bill, I'm afraid that there might be some code revision games there. And basically, what the amendment did that was passed by the full House, that was approved by the Rules Committee and the Public Safety and Homeland Security Committee, is it provided an affirmative defense that said that if the person honestly didn't know that the person was prohibited, then they wouldn't be held liable. To me, as a firearm owner, if I was providing a firearm to someone I knew was a prohibited person, that would certainly be problematic. But if I was providing it to any of you in your capacity as being a representative and I was providing it to you that way, I didn't know that you were prohibited, I shouldn't be held liable. And that's what that committee proffered, and that's what the House approved. So to the extent that that would be something that the committee would consider, I'd be grateful. Lastly, under section 4-4, of the bill regarding the possession of a firearm by a convicted felon. I have two things here that I believe are of merit to bring as a matter of public policy. First and foremost, this is something that I'd like to mention. This was co-chair Reeves of this committee 2 years ago, back in 2016, did with the terroristic threats. Currently, this bill proposes to enhance the criminal penalty in regards to what's considered a forcible felony and to bump that up to 10 years, especially for the second and subsequent offense. But this code section, although it doesn't provide for that reference, the definition of what's considered a forcible felony is currently already law and a cross-reference to the actual code section that's on file with the Secretary today. And forcible felony includes terroristic threats. Well, it was at the time, terroristic threats was always a felony. But what Co-Chairman Reeves did under House Bill 874, which was Public Act 606 of 2016 post-gubernatorial ratification, is it changed the crime of terroristic threats to a misdemeanor unless the terroristic threat, the underlining threat, was a credible death threat. And in that event alone was the crime considered a felony. So to the extent that there's a broken cross-reference there, I would ask that this committee consider the appropriateness of writing subsection E of this code section into the bill and to delete the terroristic threats language and insert in lieu thereof credible death threats so as to be consistent to what is public law, because under current law right here, under subsection E, it just says terroristic threats. So it would have made sense had that bill not passed, because terroristic threats would have always been a felony. But it's not the case anymore. A person who's convicted of a terroristic threat, that's not a death threat, that's only a misdemeanor, which means they wouldn't be a convicted felon at all and wouldn't be subject to anything that Section 4-4 seeks to address. And then lastly, this is also part of the bill on line 973 of the bill. It says, or by a court of a foreign nation. And I guess this is more of a public policy question than anything. But as you know, the General Assembly has a current criminal prohibition against recognizing foreign laws. So to the extent that whether or not it's a good public policy venture for the General Assembly and for our state courts to recognize foreign judgments, there are nations out there where persons might get a fair trial, but there's certainly many that they won't. Due process considerations, right to counsel, right to be free from cruel and unusual punishment. There's nations in this world that will whip and cane people to this date. Singapore does, for example, and there are other ones too, including Middle Eastern nations. Good luck trying to get a fair trial in a country like North Korea. You won't. So to the extent that the General Assembly currently has codified a criminal prohibition against the possession of a firearm by a convicted felon arising from an out-of-country foreign conviction, that's something that's not addressed under federal law. Federal law doesn't recognize foreign felonies or foreign felons for the purposes of possession of a firearm for that very reason. There's nothing under federal law that addresses that. That's something that certainly some Democrats there would probably like to amend into that, but it's certainly not addressed, and it's because there's no adequate due process consideration. So to the extent that the General Assembly currently has codified a criminal prohibition against the possession of a firearm by a convicted felon arising from a foreign nation's judgment, I would ask that the General Assembly consider the appropriateness and venture as to whether, as a matter of public policy, that should be wrote out of this as well. And those are the four concerns that I have, and again, it's my hope that this committee will address them. I did say all this to the other Canberra, and I understand that this is the governor's bill. I understand the reluctance in wanting to venture too far into amending it or touching it, because it is the governor's bill, and I understand the politics behind that. But I just think that these are four public policy questions that are just too big to just simply be ignored, and I do ask that hopefully someone on this committee will have the courage to address them and as to whether or not they should be amended as ventured.
Vice Chair.
Thank you, Mr. Weaver. I just want to say, first of all, you have an amazing memory, and the issue you brought up with terroristic threats, I will commit to you to work with the author and make sure that we have done that correctly. So thank you for bringing that up.
Well, thank you, Mr. Co-Chairman. That certainly helps allay my concerns in regards to one of my four, but I continue to be cautiously optimistic that the committee will venture to explore the other three, and it's my hope that that will be part of the discussions moving forward.
I see no further questions. Thank you, Mr. Weaver.
Thank you.
Is there anyone else who'd like to be heard in support or opposition to Senate Bill 407?
Yes. Thank you,
Yes,
Mr.
sir.
Chairman, and members of the committee. My name is Burl Ellis. I'm the former CEO of DeKalb County, and I'm currently the political director of the ACLU of Georgia. The ACLU of Georgia supports Senate Bill 407 in its present form as a step forward, but for the record, I would like to suggest how we might do better. And I want to focus on 3 constitutional principles. First, the presumption of innocence is a fundamental principle of due process under the U.S. Constitution, and we suggest that there be a statement affirming this long-recognized principle, a presumption of innocence, in Part 2 of the bill. Second, we suggest that there be specific language affirming the presumption of release for bailable offenses. The U.S. Supreme Court recognized long ago the fundamental right to pretrial liberty, except for carefully limited exceptional circumstances. Section 2-4 of the bill requires courts to impose the least restrictive conditions possible and speaks against excessive bail. And this is good. However, since the least restrictive condition is release without cash bail, we would like to see the bill state just that. Third, we ask your consideration of the purpose of bail in the first place, which is to ensure appearance in court. We propose more use of citations in lieu of arrests rather than arrest by citation for low-level nonviolent offenses. Sections 2-2 and 2-3 are steps in the right direction, but fail to go far enough. Specific authority to issue citations in lieu of arrests would reduce jail time, save taxpayer dollars, promote safety by keeping officers on the street instead of spending hours transporting people to jail for petty violations, and remove collateral impediments of an arrest record, such as housing and access to education and job opportunities. Finally, we opposed, can you hear me? We oppose the proposed sentencing enhancements contained in Section 4 of the bill because these are not criminal justice reforms. They're more of the same failed policies that have filled our prisons, driven up taxpayer costs, and failed to keep us safer. I stand here today as living, breathing evidence of why it matters to have the Constitution. Because of the Constitution, we have a Bill of Rights. Because of the Constitution, we have guarantees of justice and liberty. Because of the Constitution, we have protections from authoritarian rule. We are protected against unlawful search, seizure, arrests, incarceration, or possibly worse. Thank God we have a Constitution. I say that from my personal experience because even here in America, I was subject to search and seizure without reasonable probable cause. Even here in America, I was subject to censure without a conviction or a criminal record. Even here in America, I was incarcerated and taken away from my family after being denied a fair trial and an appeal bond. And so we must recognize that even here in America, injustice can occur because the system, as good as it is imperfect. But because here in America we do have a Constitution, I had a right to appeal. It is that constitutional right that reversed the wrongful conviction and restored my freedom. And as we move to becoming the more perfect union which we espouse, we must hold true to the principles embedded in the Constitution. Principles such as the presumption of innocence, the presumption of release and liberty, and the purpose of bail in the first place, which are designed to ultimately protect all of us and ensure our freedom. We thank you, members of the committee, for your time and for your consideration.
Thank you, Mr. Ellis. Mr. Rotundo, you look like you wanted to say something.
I will make it short, sir.
Okay.
My name is Frank Vincent Rotundo. I'm the Executive Director of Police Chiefs for Georgia. I sent this bill to the membership of my association, the leadership of my association. They asked me several questions about the bill that I was able to ask and I was asked, and I answered for them. There was one area I couldn't, and I obtained that information. They're very pleased with the makeup of this bill. We think it's a revolutionary change, very positive step towards good freedom and liberty for all. Thank you.
Thank you, Mr. Rotundo. Mr. Rotundo is the Executive Director of the Georgia Chiefs of Police, for members who may not be aware. Mr. Norris? Terry Norris is the Executive Director of the Georgia Sheriff's Association.
That is correct, sir. Thank you. Thanks for a moment of your time this afternoon, Mr. Chairman, members of the committee, and our friends in the audience. And Justice Weaver just left, so I'm not going to have his assistance with my testimony today. But we are too impressed with his recall, Co-Chairman. Not here to offer anything but a little bit of a concern and two parts of the bill, if you will indulge me just a minute. On page 10, and I spoke with Mr. Miller earlier about this, and page 10 at lines, 333, 4, and 5, talks about a sentence of 12 months for certain offenders. And Mr. Miller did explain, and I trust him in his judgment on this matter. He probably knows more about criminal justice reform than he even chooses to. But we probably already have these particular felons in the county jail. But I use this particular section of the bill to bring forward a little bit of information about county jails. There are 143 county jails in our state, functional jails. Every county does not have one. Those that don't, those sheriffs and counties contract with surrounding counties that do have jails. In the February jail report, these are numbers reported by sheriffs through GCIC and the Department of Community Affairs. There were 37,699 inmates in county jails in those 143 jails. That was up about almost 1,000 from the previous month. At the same time period, there are 26 jails over capacity. There were 2,312 inmates sitting in county jails that had been sentenced to the state correction system. That was up about 100 from the previous month. The number of inmates awaiting trial, and this is an important number, we all know that jails are envisioned, designed, created to house people awaiting trial. That's why we have jails. There were 23,555 inmates awaiting trial as a result of that month, and that was up a little bit from the previous year. That's about 62% of people in jail are awaiting trial, and that's a number that's been fairly consistent throughout time. So I tell you all that to say this. Today, in the Henry County Jail, the Georgia Sheriff's Association headquarters is located in Stockbridge, Georgia, south of Atlanta, Henry County. In the Henry County Jail today, there are 801 inmates in the Henry County Jail. 364 of those 801 inmates are in there, and they cannot be released. They are in there for parole violations and probation violations. That's about 45.4% of the jail population. And remember, there's only 62% awaiting trial. So they're part of that 62%. In Walton County, today, 458 in the county jail. There's about 217 that are in there held solely on a probation or parole warrant, which is about 47.3%. My point for saying and bringing all this up is this. There has been a significant shift in cost at the state level, but some of these costs undeniably have been sent to the local taxpayer. These people are sitting in county jails that I just mentioned, 47% in Walton, 45% of the population in Henry. They're sitting there, some of which are misdemeanor violators, but the rest of them are state offenders sitting in a county jail that you and I as local property taxpayers are footing the bill for. So at some point, we hope to have a conversation about ways to reimburse counties. And this is not it's in the sheriff's budget, but it's the county governing authorities that must appropriate that budget for the sheriff's office. So we have a growing cost as a result of criminal justice reform. wanted to make that point. The other point I wanted to make, issue appears on page 6. I am convinced that the author of the bill, my senator, actually Brian Strickland, is a senator for the Sheriff's Association and a great friend, a great supporter, as is Mr. Miller. And they both assure me of this, and I read it the same way. It relates to citations. Now, really, even today, you can arrest just about any misdemeanor offense on a citation. You can issue a citation and let that person go, for the most part. It doesn't always happen. It happens in the metro Atlanta area more so than anywhere else. And I am certainly trust the language in the bill to say that if you're issuing citations on these other 4 offenses, that you do, it does come with a fingerprint. These are fingerprintable offenses, and they would be fingerprinted. My issue is this. If we issue a citation for these offenses and we let the person go without the print, then when that person comes back to court, that means somebody's got to obtain that print. And my fear there, not so much in metro Atlanta, but in the rest of the state, if they come back to court, then the sheriff's going to have to some way get those individuals from court to the jail to print them, to get them back to court at some point. So there is a little bit of a logistical issue there. Second thing is identification. If we truly issue a citation without a print at the time the citation's issued, we use a name check to find out who that person is. And the only true way to determine a person's identity is a fingerprint check. So those are some concerns. We're not going to say much else about it other than this. We do appreciate your time. We are concerned with the unintended local costs as a result of some of these things that have occurred over the past few years. So thank you, Mr. Chairman.
Just to be clear, your last comment about some of the things that have occurred over the last few years.
Some of the reforms, as I said, the largest segment of the jail population, that growing segment, we believe, are the people who are on probation or parole, who are rearrested for a new offense or sometimes a technical violation. And they're, like I said, that segment is growing in the population. 45% is a pretty big number of folks that are under some sort of sentence already. And those people are housed in the county jail solely at the cost of the local taxpayer. So there's not, and some of those offenders have come because of some progressive ways of thinking about how to deal with crime and criminal justice in our state. So it's hard for me to pinpoint one thing that's occurred over the last few years.
Well, but I mean, if they've been revoked or they're reoffending, I mean, they're going to end up there anyway. I don't see how that relates to our measures here. I fully understand, by the way, just to make sure it's clear, I mean, I fully acknowledge the main catalyst I would think for that, or one of the main catalysts I would think for that, other than just your basic reoffender, coming into the local hotel, is when we went ahead and adjusted the felony thresholds on the theft crimes.
Right.
That, of course, hadn't been adjusted in forever and a day. And we actually came into line. I think we came in straight in line with the rest of the country, somewhere between 1,000 and 2,000 on your various, theft crimes. So we were way behind on that. 300 on a felony threshold I mean, that just doesn't pass a straight face test. But we went ahead and made that adjustment. I fully acknowledge that would go ahead and create more pressure on the local jail. There's no doubt about that. The only question is over the course of what period of time. You see things in a trend I've found in business over the course of 3 to 5 years. And I don't see why it would be any different, in looking at a local incarceration rate. But they're separate and apart from that, which I just wanted to publicly acknowledge because, we don't not get that. We get that.
Sure.
It's those reoffenders would come in and they'd be at the Neil Warren Hotel regardless, right?
Well, some of them would,
Yeah.
but I think there's a legitimate reason to keep people out of prison and out of jail, certainly. And people ought to have second chances and,
I mean, when they're picked up is what I'm saying. When they're picked up and they're waiting, I mean.
But there's no way to get them out because there's no bond set when you're on probation or parole and you're in jail. So you're sitting there.
Mm-hmm.
Some of these people, too, will never go into the system. A lot of them are misdemeanors, so that, obviously, they're not gonna go. They're gonna serve their time in the county jail. That occurred as a result of changes in the law in the early 90s, when we took misdemeanor probation or misdemeanor offenses away from the Department of Corrections and the state supervision. So some of that is a misdemeanor, but some of the others, they can't get out either way. They're in there on a probation violation warrant from a misdemeanor probation company or a county or city. So they're sitting in that jail. But the same token, our state probationers and parolees who reoffend are sitting there too. Now, there's never really been any reimbursement to the counties for holding those state inmates. But that is, for years, that's what we talked about down here, the backlog of state inmates. We don't talk about that as much anymore because the inmates that are sitting there now are not inmates necessarily, although there's 2,300, they're not the ones that are sitting there that have been sentenced and are waiting for the sheriff to take them to the prison. They're the ones that increasing number of probation and parolees, because we are trying to get people out and trying to let them live in free society that can't comply with rules, and they get rearrested for a technical violation or a new offense, and then there is no bond. And a lot of times what happens in those cases, those inmates will sit in that county jail until there is the bond hearing, the revocation hearing, and by that time, a lot of judges will say, well, your sentence is almost over anyway. So the unintended consequence is a lot of state inmates are serving their time in county jails, and it's at our cost. And I'm not here to ask for any relief from that today. We all know that, and I think we can work going forward, hopefully, and get some relief for the counties.
So by the time they get their hearing and they've been waiting on their hearing on the revocation, the judge will take a look at it and say, time served, goodbye.
Yes, sir.
Okay. Mr. Reeves. I'm sorry, Ms. Silcox.
Thank you, Mr. Chairman. I was just curious on the fingerprinting proposition that you mentioned in section 2.2. Was just curious, is there a possibility of having a mobile type unit where fingerprinting could be done? I mean, is there an app for that?
There's, I don't know if there's an app. There is the fingerprints go, there is a mobile AFIS, automated fingerprint identification system, that goes to GCIC, and that's where all the prints go to GCIC and the National Crime Information Center once they're arrested and booked. And yes, there are mobile units. In fact, Chairman Reeves County has a mobile unit. I talked to those folks today. But that, and it may happen in other metro counties, but that won't happen in the rest of the state. Too many places in the rest of the state.
Is it too expensive?
Yes,
or-
ma'am.
Okay, thank you.
Yes, ma'am.
No further questions. Thank you, Mr.
kindly.
Norris.
Y'all have a good evening.
Thank you.
Chairman Gold, I didn't stand up, but can I say something in response to what Sheriff Norris just said about the split sentences piece at line 333?
Sure.
Okay. I just want to really quickly, Marissa Dotson, Public Policy Director at the Southern Center for Human Rights. I just wanted to clarify what the council was trying to do, or that language there with regards to allowing.
Where are you again?
At line 333, I think is where Sheriff Norris called your attention. This is when it says when a defendant with no prior felony conviction is convicted of felony offenses or is charged with a felony offenses. Are you all with me? This is regarding probation of not more than 12 months of imprisonment. What we were getting at, Judge Deal actually brought this to the council, and the issue is that this is for behavioral incentive dates. So whether or not someone could get a 3-year window of time. Will we terminate your probation early after a particular period of time? Remember that this only applies to a particular class of offenses. What we were running into practically is that if someone had a split sentence, you couldn't get this behavioral incentive date. The concern is for someone who was in a county facility for a month or 2 months or 3 months prior to being sentenced to a prison. The concern is that they spent any time in county jail and the court granted that individual time served, then they would be ineligible for a behavioral incentive date. What we're trying to do here is allow courts, when someone has spent any time in a county facility, less than 12 months, to be able to, even if they're given credit for that time served, that they would not be prohibited from getting that behavioral incentive date.
I thought I understood it. Now I'm just confused more.
Sorry. I'm sorry. I mean, I think what made me stand up to bring a concern is because I think we were getting into backlog and what's happening at county jails and who's who's there and for how long and who's paying that cost, that is not at all an issue in this bill. This is only trying to deal with the behavioral incentive date that was created last year and making it clear that individuals who spend any time in county jail before they are sentenced to prison, that process of spending time in the county facility before being sent to prison would not be considered a split sentence.
That's not your issue, maybe his issue.
I mean, I recognize that Sheriff Norris raised lots of issues for this body to consider. I just wanted to be clear that what was going on in this bill was not at all about any of those concerns that I'm sure this body and others might take up at a later date.
I think and I'm not putting words in anyone's mouth, I think it was just the concern of that association on the net effect of what we may do.
I don't think this changes
how I felt that, how I took that.
This doesn't change any of the current processes for individuals who are in county facilities at all. This language will not make any reforms.
We'll probably do a deeper dive into that area.
Okay.
Any questions for Ms. Dotson? Seeing none, thank you. Is there anyone else who'd like to be heard on Senate Bill 407? Going once. Okay. Appreciate the author. Thank you. Mr. Miller, I'm sorry, Mr. Hightower, did you have any questions as a former member of the committee? All right, thank you, Judge, for being here. We appreciate your time and your attention. And we're adjourned. Thank you.